Hi, everyone. Good afternoon.
Good
Welcome.
afternoon.
Good afternoon.
Good
We
afternoon.
appreciate you all being here this afternoon. Thank you for being with us. Good afternoon. Welcome, everybody. Got about 80 folks and counting joining us. Oh, I forgot to disable the wait room. So there's more people coming in. Hello. Hello, everybody. Thank you for being with us. You have made it to our juvenile court webinar for our fiscal eligibility staff. My name is Geraldine Bordage. I'm a child welfare specialist here at the Resource Center for Family Focused Practice. I'll be supporting today's webinar along with my colleague, Mallory Marsh. Mallory? We're expecting quite a few folks to join us today, so we're just going to wait for just a little bit longer to get started and let everybody connect to their audio and get settled in. So while we're waiting for everybody, I'm going to go ahead and start sharing my slides. Second. Lots of screens to maneuver. All right, so here is our slide deck. All righty. So again, welcome. If you are just joining us, you have made it to our Fiscal Academy Juvenile Court Overview webinar for our fiscal eligibility staff. Again, my name is Geraldine Bordage. I am a specialist here at UC Davis Resource Center for Family Focused Practice. If you're already settled in, ready to go, please say hello in the chat. Let us know who you are, what county you work in, and if you'd like to answer our icebreaker question, what is your county famous for? And I'll take a look in the chat. Let's see what everybody is putting in. So I'm coming to you from San Diego, California, out here in Southern California, and San Diego County is famous for, one of the things we're famous for is the San Diego Zoo. All right. Kern County, Mendocino, Solano, awesome. Placer. Okay. Sharks, jumping frogs, Route 66 and the first McDonald's. Cool. Awesome. Very cool. Take note, everybody, if you ever go on a trip up and down California, here's some resources for you to think about. Very cool. Ventura's here, Santa Cruz, got lots of representation from all the counties. Very cool. I want to go to Humboldt County. That is on my to-do list for California for sure. Very cool. Santa Barbara is here. Awesome, everybody. Thank you for that information. So again, if you're just coming in to join us, my name is Geraldine Bordage, and I'm a specialist here at RCFFP. I Prior to me joining RCFFP 2 years ago, I was actually in San Diego as a social worker for child welfare services here. So I worked here for over 22 years, and half of that time was doing direct practice as a social worker. So I carried cases and often worked with our eligibility staff for my court-involved cases. So I now oversee our Fiscal Academy projects here at RCFFP. Definitely learning a lot more about the eligibility side of the work and just how technical the work can be. So thank you all for the work that you're doing to ensure that funding for our youth in care is available, right? And being in the trenches with others who are also making sure our children, youth, and families are coming out better on the other side of being involved in child welfare and probation. So again, thank you for being here today, and thank you for joining us for this afternoon. I David Myers will be our presenter for today, but before I have him introduce himself, I want to find out just a little bit more about you all and see who's joining us today. So I am going to launch a Zoom poll. Oh, there we go. Mallory did that for us. So there's just some three questions in there. If you can just take a few seconds to answer that. So what is your role in foster care eligibility? How many years have you been in foster care eligibility? And then I just want to get an understanding about your, or get an idea of where you're at with your understanding and knowledge of how the juvenile court system works. Awesome. All right, lots of folks answering, so I will share that poll in just a few more seconds. We're about 63%. All right, and I also see in the chat, there's some analysts that are included that are here with us today. Okay, awesome. Very cool. All right, just a little bit longer. We're at about 77% answered. And we're still ticking up. All right. Well, we're holding steady at 80%, so I'm just going to go ahead and end the poll, and we're going to share the results. All right, so some of you saw in the chat, there's some analysts as well that are included. I think we have other fiscal staff, it sounds like in the chat as well. So primarily 53% of you are staff. And really what we meant by that is like the eligibility worker, right? Doing the actual eligibility work. 19% of you here today are supervisors, 9% are managers, and about 20% we didn't capture in this first question. But some of that information is in the chat if you're interested in knowing who else is here with us today. And look at that. How many years have you been in foster care eligibility? 57% of you have been in this work for less than 5 years. So that really tracks when I've heard from other counties that there's a lot of new staff coming in that are really in need of that support to onboard them in their role. So wonderful to see that. It's the same here as well. So thank you for being here today for this webinar. So we hope that you will get something out of today's presentation to help you, do your job a little bit better on a daily. Okay, and then rate your understanding. Okay, so I think I saw a Law and Order episode of this one time. There's 26% of you that rated that. You can explain a little bit, maybe know a little bit, 14%. And the majority of you are falling in the number 3 there, where you just know enough about juvenile court to do your job. So exactly 50% of you that answered the poll are in there. Very cool. All right. Thank you very much for that information. That kind of gives us a little bit of idea of who's here with us today. So I will go ahead and hand it over to, let me just make sure I have David on here. Okay. I'm going to hand it over to David to introduce himself and move us forward.
Awesome. Good afternoon, everyone. Let's see. There we go. Okay. So, hi, everybody. First request for the two people that put um, as the answer, they are experienced enough to teach this. Could you both send me a private message in the chat saying, I did that, or something like that? I want to know who you guys are, if we've met, because I really want to honor that, and I want to encourage you two to help me in the next 80 minutes that I have with you, rather than bore you with what you already know. So if you are one of those people, then yeah, let's do this. That's two more instructors that I get to work with. Yay. Um, And so I am monitoring the chat myself. If you have questions as we go, please put it in the chat. Don't be afraid. If you have a burning issue or if there's just something that you have to shout out loud that's so exciting about this topic or relevant, unmute and let's do it. I want to encourage that too. This is not the next 79 minutes are not going to be, I just have to sit and listen to this. Although that is what most of you will do. Actually, I take that back. Only about half of you will actually listen. The rest of you will be checking your email or texting or planning dinner for tonight. I get that. So, in that spirit, actually, I want to encourage you. In fact, let's do this. Go ahead and put in the chat if you're actually listening. Um, Either one of two things. Either A, something you were looking forward to hearing about in this webinar, or in the alternative, why you think this is going to be a waste of time for you. Um, and so I would like to know that as well, so that I can get inside of your heads. Remember the rule of group. If one person's thinking it, chances are a lot of people are thinking about it. Um, so I'm interested into as to, why you might be looking forward to it. Um, I also want to start with this. I'm not a slide reader. So the first thing out of my mouth, um, is I want you to thank Geraldine. She put together 102 of these slides. They are the best content slides I have ever seen. And so you're going to get a copy of these slides. Thank you. I'm loving the chat. Keep it rolling. I feel like it's a Twitch feed. You guys are going so fast. Holy cow. For those of you who have kids, you know what I'm talking about. That's the only reason I know, trust me. Um, and so I want to get back to Geraldine and the slides. These content slides are incredible. And so my hope today is not to have you all leave here with the knowledge contained in all of these slides. That's a lot to ask for 102 slides in 78 minutes now. And we will get to it, I promise. But I do want you to know that the content is here in the slides. Geraldine's amazing, and her contacts at the end of this too. You can get to me through her. You can get to her. She notices. Yeah, exactly. Thanks, Gary. And so I'm going to get into when I first started teaching years and years ago, I had a brilliant mind, social worker like you guys, eligibility worker, who had worked in eligibility. He said to me, "Remember when you're teaching adults, you can only teach them three things. Um, you can teach knowledge, skills, or values." Um, and so most of your training, almost all of your training is knowledge based when you're an eligibility worker, and that's great. Some of your trainings are skills based as well, where you're taught how to do something and then you have to do it back. Demonstrate it during the training that, you watch a demonstration and you do too. So you get a lot of knowledge and skills trainings. There's going to be knowledge in this training as well, but I really want to give you a values training today because eligibility workers very rarely get that. And my goal is to have you leave here saying two things. Number one, that was actually interesting. Um, and then number two, going, yeah, I actually got something out of that in terms of why I do what we do, and how that goes. Um, and why things are the way they are. So I'm going to try to focus more on the values. I don't read the slides. So if you want to get anything out of the slides, um, take a look at them. If you want to get anything out of the slides during my presentation, you will look at them. There are some slides I will stop and I will focus on. They are eligibility specific, but the vast majority of these slides are really designed to it's sort of a front of the house, back of the house situation. Um, and I just want to pull back the curtain and go, here's the juvenile court. Here's what it looks like. Here's what we do. Here's what we think. I myself am a lawyer. I've been doing this for plus 30 years now because I'm just that old. I have represented literally everyone who could come before a dependency judge, including tribes, CPS, or the age social service agency, whatever you call yourselves, DCFS, DFCS, CSA, DFACS, CPS, HSA, HHSA. I think I got them all. All the acronyms I represented: kids, parents, relatives, caregivers, foster parents, tribes, you name it, I've done it. Um, And I even sit as a hearing officer now these days to do some of the khaki cases, which I just love. Um, so Okay, thank you. I'm watching the chat, loving it. Keep going with the chat, especially as thoughts come into your head. So, if you, I would encourage you to be looking at the slides. I will stop at the ones that are very eligibility specific. The other ones, I may not say anything other than just the stories that I tell. This is the overview of the juvenile court. And these are basically the hearings. Juvenile court is a very linear process. When you get in to the court process, it goes in a very linear direction. There are um, very specific statutory rules that apply. And so there are two types of courts in the juvenile court. One is the dependency. That is the court where there are no parents or guardians who are capable of keeping this child free from abuse or neglect. You got to remember your basic divorce, custody situation. Um, in those cases, it's presumed that both parents can parent the kid. And so you're dealing with, well, what's best for the kid? Now, obviously, it's never that friendly for those of you who have either been through or know anyone who's been through a custody battle. Those are nasty. And those are based on the presumption that both parents, excuse me, both parents can parent the child. And so, what's going to be best? Which school district, who's going to be the soccer coach, blah, 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 blah. And of course, if you were one of those, or if you're vested in a custody battle, the other parent can't really do it and they're just making crap up. But that's what they're saying about the other parent, too. And I don't like family court because, as a judge told me when I first started practicing, in criminal cases, you see bad people at their best, and in family law cases, you see really good people at their worst. I have found that to be true. I don't touch family court. But dependency court I really like because those are the cases where neither parent and there's no legal guardian can function. And so the government, aka you guys, the government has to come in and quote protect these kids. The vast majority of our cases, we deal with abuse or neglect. But depending on who you believe, only about 6 to 40% of our cases deal with child abuse. That's physical abuse, sexual abuse, even emotional abuse, which is squishy. Those are not the majority of our cases. The majority of our cases are what? They're neglect. And what's neglect? Neglect is pretty darn subjective. We know when we see drugs, we know when we see domestic violence, we know those have bad impacts on children. But how we quantify that and how we choose to remove a child based on neglect can really vary. Your county, and I've seen them all plop up on the screen. The same set of facts, the exact same family, cross county lines are going to have two different results potentially if there's drugs going on based on who the supervisor is, who the county council is, who the social worker, what's happened in the pet. Do you have any dead babies recently? That's going to cause the numbers to go way up. So the people's politics and personalities really drive who comes into a dependency court when the government makes a decision to remove a child from a home is way more subjective than objective. Much of the teaching to social workers is very objective. You learn about safety organized practice and risks, harm, and danger, and you're trying to objectify. And sometimes that's really easy to do. You got broken bones, you got sexual abuse, it's a no-brainer. But when you're dealing with drugs and domestic violence, which is about 80% of our cases, it's squishy. Because if you're from a white upper middle class home, you're probably not going to come before the dependency court just for drugs or domestic violence. But if you're a poor person of color living in a rural area, you're probably coming through. Um, that's not this class, but that's also our reality. The other kind of court is the juvenile justice court. I get my hand slapped when I call it delinquency court because the new nomenclature is juvenile justice. Um, but these slides refer to it as delinquency. Both I might slip and use delinquency. If that happens, I know this is being recorded, but make sure the judges don't watch this if I say delinquency court, because then they'll slap my wrist again. And it hurts. So juvenile justice is that's when children commit status offenses like truancy or smoking underage, things that are not really crimes, but they are criminal for children in nature. We don't call them crimes, but we call them status offenses, or when they commit actual darn crimes. I know John Oliver just did a last week tonight on juvenile justice and juvenile incarceration. I fell asleep during it, but that's neither here nor there. We could talk about my personal life after the webinar. Um, but it was really actually pretty good. So if you're interested, and you don't have, if you have HBO Max, hop on there. It was a really good summary of how we treat our children who commit actual crimes. What I will say, the goal of juvenile justice, and the reason we call it that as opposed to criminal, is because the goal is not to punish. The goal is to rehabilitate. The goal is to catch them while they're young so that by the time they turn adults, they're healthy, happy, functioning young adults. And that works every time, all the time. We have zero incarcerated population that used to be foster kids. Oh, wait, I'm wrong. 80%, 75 to 80% of our incarcerated problems had some dealing of our incarcerated inmates in this country have had some dealing with our juvenile court system. That's how bad of a job we do raising kids. But all of you are here as eligibility workers to help ease that burden by ensuring that these kids get the opportunity to get what they need. And that's why your role in the system is so critically important because without you, these kids have a 100% chance of failing. With you, these kids and families have a chance of success, and there are success stories. Um, so California is a county-based system. So there's 58 different counties, 58 different juvenile courts. Each county has at least two judges. So if you're from a small or remote county, you're going to have two. Larger counties have more. Um, there are state laws. Our Welfare Institutions Code is really what governs our juvenile court, starting with Section 300 for dependency. That's why we call them 300 cases or 300s. And then 600 really 602, 600 and 601 are odd sections, which you could look at. But 602 is what governs juvenile justice. And so that's why we call them 602s, or delinquents or juvenile justice matters. And so, yeah, judicial officer has the authority. I think we talk about judges a little bit later, like now. Um, Judges are political creatures. They are either appointed because they are well connected or they win in an election. So they are very political creatures. Judges do not like to see their names in the headlines. Judges do not like to be challenged. Judges do not like to be told that they will be impeached if they don't rule a certain way. Um, this is not the course to talk about the three branches of government. Um, but I'd be remiss if I didn't mention the three branches of government: executive, judicial, legislative. You all work for the Oh, what? Yeah, you all work for the executive branch. Think about it. The legislature, Congress, right, makes laws. And in the late 1960s, they amended the Social Security Act. By the way, how do you cite to the Social Security Act? All of you know this question. The Social Security Act. It wasn't Title One, it wasn't Title Two, it wasn't Title Three, it was Title Four. Guess what subdivision? Oh yeah, Title 4E. In the late 1960s, Congress amended Title 40 of the Social Security Act to say that when a child comes into foster care, we will reimburse you for a percentage of the cost of foster care. That is why all of you exist, because you are sort of a product of the late civil rights movement. And so Congress made that law that said feds will pay for kids that come into care. That's why all of your agencies didn't crop up until the early 1970s, right? Because the legislation passed in the late 60s, and it took a few years for all the states to get together to say, hey, we're going to get some free money from the feds. And your job is to ensure that the money flows. And it's a critical, critical job because that money is what keeps some of these kids alive, and keeps some of these families healthy. So super critical. Um, but so legislature made the law. The executive branch, that's all of you, you execute the laws. You literally are executing a law by sitting here in this boring old training today, because you're told to be here. But part of doing your job is understanding how the juvenile court works. And so you've been ordered pursuant to either a law or a mandate or a policy to come and do training. And everything that you do is part of your job. Thank you, Amy. You're my favorite now. Um, everything that you do is pursuant to some mandate to do it. So you are literally executing laws and mandates. And if you ever don't want to get sued, you have immunity. So as long as you're executing a mandate within the four corners of that mandate, you're rocking it. You're rocking the job. So don't drink on the job. Don't lie. Those kinds of things. That'll get you in trouble because you're going outside your mandate when you do that. But if you stay within your mandate and you do your job, you will be executing laws in a really fun and exciting way, or at least in a way that gets you paid every 2 weeks, which is even better. So now we're talking about the third branch of government, the judicial branch, which I will explain with a very unfunny joke. Um, but it really does illustrate the role of the judicial branch, and we have time for it, so I'm going to do it because at 1:30 I'm going to move into the more detailed slides. Um, Gate between heaven and hell breaks one day, and God looks down at the devil and says, "Oh, the gate we shared is broken. Can we fix it?" The devil looks up and says, "I'm not fixing it." God gets annoyed. He's like, "No, no, no, fine. I'll just fix it. You reimburse me half the cost." Devil looks up and says, "I'm not giving you anything." God gets really frustrated. He looks down at the devil and he goes, "If you don't fix it, I will sue you." And I don't know why God is Italian in this joke, but he is. If you don't fix it, I will sue you. The devil smiles and he looks up and he goes, "Yeah, where are you going to get a lawyer?" Not at all funny. Not at all funny, but very indicative of the role of the judicial branch. If you don't fix it, I will sue you. Accountability. That's why we have a judicial branch. Thank you for humoring me. Um, that's why we have a judicial branch. Is to hold the executive and the legislature accountable, interpret the law. That's what we do. And if you're watching the news, you're seeing examples of this being tested on a daily basis. And it's good. Our system is working. So everything you do is subject to some kind of judicial review. Now, eligibility rarely, if ever, comes before the juvenile court, but it can. I've seen it in my 30 years. I've seen the eligibility be the issue, especially when it comes to, especially as a child's lawyer. If a home is deemed not eligible, but a kid is there, we're going to drag the department in to get this thing paid for. So it can happen, but that's the point. If you don't fix it, I will sue you. Executive branch, if you don't do your job, you will be held accountable. And because you are the government taking other people's children, or trying to punish other people's children by putting them in the juvenile hall or somewhere else, then the judiciary comes in to hold the executive accountable to make sure they're executing the law properly. That's how it all works. And judges are the ones who sort of run the role. I love that this slide says judicial officers because some counties have commissioners, referees, magistrates, judges. For purposes of today, they're all the same. They all wear that silly black robe, and they're all subject to accountability by the appellate courts and higher authorities. Happy to go into all of those if there's time at the end for questions, but I really want to give you more of an overview of the juvenile court. But remember, judges are political creatures, and they have two mandates. One is to follow the law, and two is to self-preserve. And so one of the things they tell judges on the first day of judging school is, and I love this exercise, they ask judges, why did you become a judge? Or why did you want to become a judge? And every one of them to a person will give an answer like, to serve my community, to give back, to do the greater good. It's going to be some BS answer like that. But it's not just BS, it's also real for these people, hopefully. And the point of that exercise is to make it real for them because they're human beings, most of them. Um, and they come, yeah, that was a joke. They come onto the bench with these high-minded ideals and a sincere desire to really want to help. And when they can connect to that, they are their better selves and they make really good decisions. When they lose sight of that and they think, ah, I'm just chugging a paycheck or I'm in this terrible assignment, I hate this work, I hate what I'm doing, they don't make great decisions. Um, Juvenile judges who stay, who love this field. People tell me all the time, "Hey, I'm going to become a judge. Got any advice for me?" And I say, "Yeah, yeah. Two things to be a good judge. First and foremost, care. Just effing care. Because if you care about the work that you're doing and the people before you, you're going to be engaged and you're going to make better decisions. The second one has to do with, yeah, know what you're doing. Which not all judges do, but most of them do, and the good ones always do. So this is the most important document you could ever have. Um, oh, thank you, Geraldine. You are a rock star. So again, credit to her. Every child who comes into foster care, from the minute that phone call is made, and it's right up at the top, the minute the phone call is made until the very end, when that kid is either returned in case dismissed or adopted, or ages out or gets off probation. This is the dependency flow chart, so I'll just talk about this. Every single child, from the minute that call is made, is somewhere on this flow chart. It's open book, which is good. When I teach lawyers and I teach judges and I teach social workers, I always say dependency is open book, which is good. And this is the best place to start. Because if you know where you are on the flow chart, if you understand where you are on the flow chart, you can get all the answers you need. So like if you look for a minute, we're going to be talking about the orange box, and we're going to be talking about the blue box, the purple box, and the yellow box, and the ones at the bottom. If you understand what each of those means and what goes in behind that, you will be able to navigate the juvenile court in a beautiful way. These are the early phases, like on the flow chart. These are the middle phases. These are the end phases. This is the delinquency flow chart. You can see there's only two phases. It's before we determine whether you're guilty or not, and I say guilty in quotes because it's responsible because these are juveniles, they're not criminals. We determine whether you're responsible or not for the crimes and the alleged offenses, and then we figure out what to do. So it's a much simpler chart, and it really mirrors criminal jurisprudence quite a bit. But we'll be talking about that too. And so, yeah, pre, post, they're all there. A word about tribal court. And I saw one of you in the chat talk about, tribes. And this is not the ICWA class. This is not the tribal class. But if you take an ICWA class, the first thing they will do in a good ICWA class is they'll remind you why we have the Indian Child Welfare Act. And again, this is not the day for that. So apologies for if you feel like I'm giving it short shrift. I really don't want to do that. I'm just mindful of the 59 minutes we have left together. Now you can tell I'm a lawyer, right? I'm always tracking things in 6 minute increments. But I am mindful of your time. So while I've got you, I want to do this. The reason we have the Indian Child Welfare Act is simple. It's genocide. Um, we, the people, your predecessors, who were not county social workers, um, but we, the people, were killing off tribes. We were sending them to boarding schools to beat the Indian out of them. This is all in the trainings that you do. And we were doing terrible things to tribes who were given sovereignty, who are sovereign nations. Each tribe is a sovereign nation, which is why we don't have like an African American Child Welfare Act or a Mexican Child Welfare Act. We have an Indian Child Welfare Act because tribes are sovereign nations. And so the way tribal court works is very different than the way state court works. And the Indian Child Welfare Act allows cases to be moved to tribal court, and now Title 4E has been amended to allow for eligibility to flow. I will say this, the good news is if you are working with a tribal court or a tribe on 4E issues, it's the same process. Intellectually, it's the same, but there may be some nuances, which I don't want to get into in a room full of 180, 166 people. Yeah, just keep an eye on the chat. Alice is speaking truth. Um, and so there is definitely some nuance to the eligibility, but the underlying principles and the foundations of 4E should and eligibility should flow to a native child, whether he's in state court or she's in tribal court. That's the same. So you're in the right place. Um, and I really appreciate it. I guess we'll get on the PDF stuff. So moving on to the purpose, I think I talked about that a little bit. All right, made it. And we are 3 minutes late, so I apologize for that. Um, so now we're going to talk about the hearings on the flowchart. So if you have the flowchart in front of you, which obviously you don't if you're one person, but you are if you're the next person. Anyway, we're just going to go right into the flowchart, and I'm just going to tell you some stories. Um, about what happens because you got the judge who's remember Article 3 of the Constitution. Judges hear cases and controversies, right? If you remember your eighth grade civics. So the executive branch brings a case or a controversy before the judge. In this case, it's a removal from parental custody. And state law is what gives the county in this case. And if you come from another state, it would be the state agency in many states. But in California, it's the county agency that removes the child. Our state law says basically, and I get some pushback from county council when I say this, but I'm not wrong. Any county social worker can remove any child for any reason. If you want to go into Gavin Newsom's home and remove his minor child just because you feel like it, you can do it. That's how big your executive branch power is. Now, the check and balance on the executive branch power is if you want to keep that child away for more than 48 hours, you have to come ask a judge's permission to do that. And that process requires the filing of a petition that basically says, hey, something really bad happened to this kid, or something really bad is going to happen to this kid. Um, and we need to come get your permission, judge, so that we can keep this kid away from the danger. And the first contact that you have with a judge at this point is the detention hearing. That's the first act of the theater. It's the first scene. It's not an act, it's a scene. Um, it's the initial detention. This is true for juvenile justice and for dependency. You come in on an initial or detention hearing. It's called different names for different reasons. Sometimes you're worried enough to remove the child. Sometimes you're worried but not worried enough to remove the child, but you're still going to come to court. Happy to answer all those questions at the end if you want to talk about the nuances. But really, the only two things happen at a detention hearing. The judge only has to ask two questions because it's not a removal. I mean, try telling that to a kid who has, you were living at mom's one day and now you're in a stranger foster home, that they weren't removed. But legally, they haven't been removed. They have been temporarily detained. And so a judge only has two questions to ask at a detention hearing. Number one, should there be a full investigation in the coming weeks to figure out exactly what's true and what's not true? And question number two, where should the kid be during this investigation? So, no formal orders are made at a detention hearing, no removal orders. It's just temporary detention. And it's just, hey, we're going to sit back. We're going to see if we should take a closer look, which the answer is almost always yes. Um, And remember, your counterparts, who are county social workers, have a tremendous amount of power. Um, when they write reports to the court, those hold tremendous weight. And what they can say whatever they want in those reports. The hearsay is admissible. And the way they write those reports and what they say in those reports, I spend hours teaching them about. Um, and so, thank you, Mallory. I don't know if you could handle that, but that would be something really cool. So they could look at that. Um, they spend hours. Thank you. Mallory's awesome. And we should thank Mallory too for being here, who is staff from our CFFP. None of this would be possible without her. So please wave and say thank you. Um, back to detention hearings. Yay! Thank you, Danielle. See, I always know I'm teaching in a room full when I'm in a room full of lawyers, everybody sits there like this. When I'm in a room full of like law enforcement or military, they're like, "You're late." But when I'm in a room full of like county workers and county employees, I'm gonna see flowers. I'm gonna see like, woohoo! So thank you guys. I really appreciate that. So, um, yeah, detention hearing is the first time that the lawyers get to meet the clients for the most part. Sometimes we get to meet them the day before, a couple days before. The kids' attorneys get to meet the kids, and I asked a client once at a detention hearing. I said, when was the last time you used drugs? And without missing a beat, she just looked back at me and she said, well, what time is it now? I'm like, okay, welcome. So the purpose of a detention hearing is really to figure out if there's something wacky going on. It's a pretty rare day that a detention hearing will get dismissed outright, because the burden of proof is low, and chances are you guys wouldn't be there if there wasn't something to worry about. The harder question usually at a detention hearing is where should the kid be while the investigation is going on? Why is that? Because there's a federal law that you will all recognize, and that federal law says, um, that the county agency has to make reasonable efforts to prevent or eliminate the need for removal, because that's a mandate, because our law says don't take kids unless it's the last resort. And yes, you can go out and take a look, emergency response units or INA or whatever you call your folks on the front end. Go take a look, but do not remove unless you've made reasonable efforts to prevent or eliminate the need for removal, or there's an exigent circumstance like, oh my God, this kid was just molested and we're not waiting. Like, but again, remember, 80% of the cases are neglect. So they have to make reasonable efforts to prevent the need for removal. And sometimes when we get to detention hearing, we can come and we can say, hey, bad guy's gone. Give us our kid back. We've kicked him out. We've made reasonable efforts. House is clean. Bad guy gone. You can test me. No alcohol in the house. All good. And sometimes judges will give the kids back at this point, because of that. Other judges, depending on your county, will never consider that. They're like, I'll believe it when I see it. This is all too new to me because these are very tight timelines. From the time of the initial yank, which is that temporary detention, to the time of the detention hearing can be as little as 3 days. And so 3 days later, you're not convincing much anybody of anything. Now, sometimes with holidays and long weekends, it can be a week, week and a half. But even then, judges are like, I'll believe it when I see it. If you guys are worried, executive branch, I'm going to stay worried until you tell me not to worry. Sometimes judges feel that way, sometimes they don't. kind of depends. Mountain almond joy's got nuts, mountains don't. Um, so for those of you who get that, drop me a note in the chat. So we're moving along. Yeah, petition. Yeah, there's the stuff. Yeah, just a word. Thank you, Rudy. I appreciate you. Um, so same for detention hearing, same for delinquency and juvenile justice. It's an arraignment. Again, it's how do you want it? Now, the one subtle difference in a juvenile justice case at the beginning is kids talk. I have never had a kid in a juvenile justice case not tell me when they did it. Like, oh yeah, I did it. I'm like, okay, I'm your defense lawyer. That's great. But if you say that to everybody else, you're going to be found responsible. So, time out. Kids don't have the wherewithal until they're much older to keep quiet. So, sometimes we can show up on day one. We can do it all in a day. We can get them out of here super quick. I don't like to do that when I have delinquent kids at juvenile justice because it's so socioeconomically driven. Some of the crap you guys did in high school that you got away with would absolutely be chargeable under 602. But most of you, I'm guessing, didn't get charged because most of you grew up not so much where cops are in every classroom or you get reported or you're at that kind of school where that stuff gets reported or you're doing it, at 4 a.m. on a Saturday in a dangerous neighborhood, whatever. So I tend to be a little softer with the juvenile justice kids because, like the parents, most of them are just, they're repeating cycles, bad circumstances and poverty and color of their skin. And so I try to slow the process down, but you can wrap things up a lot faster in an initial hearing, a detention hearing in a juvenile justice case. It is very rare to do so in a dependency case, but I've done that too. Right case, like it's more, but it's definitely the exception. And here's when the petition's filed. Again, these content slides, Geraldine, are amazing. Thank you. And I really want to encourage you all to focus these. Yeah, they happen very fast. We talked about this. Um, okay, slow down number one for you guys, because this is a very critical part of your job, is to understand the DEFC, the date entered foster care. The law is clear as mud on this, but once you do it enough times, you'll get better at it for dependency case. It's either 60 days after the child is yanked. That's the temporary detention, physically removed. That's why it's written this way because it's not a quote removal. It's a temporary detention. But if the kid is temporarily detained on day one and then day 60 comes and that kid is still temporarily detained, that's going to be your date entered foster care. Unless unless you were able to get to the next hearing within those 60 days and make some true findings, then your date's going to be earlier than 60 days. I hope that makes sense. It's either going to be 60 days if the case, if you're in Los Angeles, it's always going to be 60 days because it takes you like 90 days to get your second hearing. So if you're an eligibility worker in Los Angeles, it's going to be the 60 days after that initial yank. A lot of large counties deal with this, but there are many cases around the state, not Los Angeles, that can resolve within 60 days. So your date entered foster care could be sooner than 60 days. And that's what this next hearing is for, the jurisdiction and disposition hearing, which I talk about together. Once a court takes jurisdiction and makes those findings, um, that could be, if that's earlier than 60 days, that's your date entered foster care. Same with delinquency. Um, Unless the child's in an ineligible facility like the juvenile hall. Actually, I'm not sure if the hall's that's a question I don't know. Is the hall an ineligible facility? I don't know the answer to that, Geraldine. Maybe you could look at it. If you don't, if somebody knows, put it in the chat. I'll believe you. Or the date is the hearing at which placement into foster care facility is ordered. That's going to be your STRTP, which can be sooner than 60 days. Again, if the case resolves and the kid goes off to the what we used to call group home or the STRTP within 60 days, it's going to be sooner. So, uh, yeah, we deny foster care. So, okay, yes, that's what they mean by it. Thank you, Melanie. That's what I thought it meant, and you just confirmed that for me. Assuming Melanie, you know what you're talking about. So it's you and me. It's our butts on the line with that. Yeah, I'm with you. It's very nuanced, but that's what the statute means about an ineligible facility. They're talking about the hall, and yes, it's very nuanced. And so if you're like Melanie, it's open book. If you have a question about the date entered foster care because a delinquent child went into juvenile hall, ask your supervisor, ask your lawyer, your county council. Do not proceed, do not pass go, do not collect $200 unless you are 100% certain about the data entry to foster care. So that's a red flag. So I want you to, when you're back at work, if you're dealing with juvenile hall, that's just like, oh, I gotta stop. I'm dealing with juvenile hall. Let me make sure I got this right. Okay? Because it's yeah, exactly. It's very nuanced. And yes, you stop the payments when the kid goes to juvenile hall, but not in every case all the time, even though you should. And so Irma's saying, but we do, which is good for Irma. But somebody else is saying, no, we don't. So trust me on this one. This is a red flag. Yeah, there we go. Um, that's right. So this is definitely a minefield. And we've stepped on a mine here. And for purposes of the juvenile court overview, if you are dealing with a kid in juvenile hall, stop what you're doing, get good advice, and make sure it's somebody else's butt and not yours if a mistake is made. Okay? That's what I want to say about that. So let's go on though, because yeah, there's this is we've talked about this. Love the parentage slide. Yeah, this one I love because I actually got this question yesterday. Somebody called me and she was a victim of human trafficking. She's 20 years old. This guy trafficked her for 3 years from like 16 to 19. Um, she got pregnant during that time. She had a baby. This guy, the trafficker, came to juvenile court and said, "This is my baby. I'm going to raise this baby. I'm holding it out as my own." And the judge made him the presumed father, which, by the way, a presumed father is the highest level of paternity one can get. If you are married um, and living together when the baby's born, you are the presumed father. You get all the rights that a father could possibly get. The opposite of that is the alleged father, which means you're not a father. Alleged father is like we had a one night stand or we were boyfriend girlfriend, we broke up. I wasn't there when the baby was born. I don't hold the baby out as my own. I don't even know if it's mine. You're not the father. You have to elevate either to a biological father through through DNA testing. A Kelsey S father is someone who tries to be the father in every way, shape, and form, but isn't the bio father. So as you can see, there is a preference to make people fathers. We want people in. We want fathers to come in. Why do we want fathers to come in? Because we want them to pay damn child support. That's why. If they're not going to be with the kid, we want to take their money. So we want everybody to be, it's like Oprah, like look under your chair. You're a father, you're a father, you're a father. And there's all these ways to make people a father. Ironically, when you come into a dependency court, we're not so sure if we want you to be the father because you're probably a bad guy. Otherwise, you would have taken this kid to begin with. So there's a huge bias against fathers in the dependency court and a huge preference to include them. Because not only do we want them to pay child support, chances are there are going to be some good relatives out there. Everybody has about 200 living relatives. This is not that training. But if you think about out to the fifth degree of affinity, think about your grandparents. Think about your brothers and sisters, or their brothers. Think about your grandparents and their brothers and sisters. Make that line on the family tree, then go down. Your grandparents, their brothers and sisters, then go down. You should get to around 200 living relatives, and those are your family members. So we like making fathers because it gives us a paternal side of the family to get relatives to. It's a lot of work for your social worker counterparts to do all this stuff, and a lot of social workers are very lazy with this, and they don't want to deal with it. They get one good relative, like they look at grandma, like, do we have a grandma? Yay, kid's going with grandma. We don't have to do any work. But if there's no grandma and they have to do this family finding stuff, like it's just like, please pay someone else to do this, please. Um, but it's really important. And I would say there's a fair amount of work. Yvonne, I see your hand up. Good. You want to drop it in the chat, or is it important enough to come on in?
I just was wondering if you could review again what Kelsey S. fathers are.
Yeah, for sure. I said it quickly. Kelsey S is a judicially created status of father. Kelsey S, the father in that case, did everything he possibly could from the minute that kid was born to be that kid's father. If you look at family, I'll drop it in the chat. It's Family Code 7611. If you look at that code section, Family Code 7611D, you'll see what it takes to be a father. And this was a guy that did literally everything he could possibly do to try to adopt this kid and become the kid's father. But he couldn't qualify under 7611D because he wasn't spending enough time with the kid because he wasn't the bio father. And so the court felt bad for him and said, "You're doing more than most fathers do, so we're going to give you status. If you make that kind of an effort and we really like you, we're gonna make you father." Here's what to know about parentage. I have a good friend who teaches parentage, and the first thing that he says, here's what you need to know about parentage. There's a case that says you can and a case that says you can't. And what I love about that comment is this is truly the most result-oriented driven area of dependency law. If you like the guy, we're going to find a way to elevate you. If you don't like the guy, we're going to find a way to screw you and keep you out. That is the beauty of parentage. It's so result-oriented, and the courts of appeal feel the same way. If we like him, we're going to laud him with all kinds of gold. Here's gold coins and riches and kids for you. And if we don't like you, you're out. So if you're dealing with a parentage issue, it's very result driven. If you want eligibility through the father's side, you have to meet some criteria. You have to get some threshold criteria. It can be done. Um, yes, Yvonne, that is correct. All the categories are considered legally responsible except alleged. Now, biological doesn't entitle you to a lot. Presumed entitles you to way more. Kelsey S will also entitle you to thing. There's also sometimes some of your counties have something called adjudicated fathers, which is a default child support order. So before the kid came into care, mother was getting some kind of benefits. She had to list the father. That agency who's paying the benefits, AFTC, whatever, they go after the father. They file a child support action against him. He doesn't even know. He never shows up. They adjudicate him the father. In the child support case, he shows up at dependency court because now mom's on drugs. And they say, hey, you've been the father all along. Give us lots of money. And the father's like, what? So adjudicated tends to fall more. Our counties have gotten so much better in the last few years about getting from adjudicated to either biological or presumed that it's not much of an issue. But as far as home removal, can we link to a Kelsey S father? Yes, you can. If the court has found them to be a Kelsey S father, that requires a very specific judicial finding, which you guys know all about because your whole job is based on very specific findings. So if you have a very specific finding that there's a Kelsey S father, you absolutely can. That is a great question. Um, and so here they are, Title 4E. Yes, well said. Please be reading the chat because there's a lot of good knowledge getting dropped in there. Loving it. So, yeah, here are the strings attached. So, as I said, in the late 1960s, when Congress amended 4E, these were the strings they said, if you want to get federal money, then the court has to make some findings. This is one. This should be here. And if it's not there, oh, by the way, I have a friend. I used to work for Judicial Council. And when I worked for Judicial Council, I did the CFSRs, which are the Child Family Service Reviews, which are the audits, the 4E audits, to make sure all the money was flowing. And my job was to go into every court in the state to make sure the judges were making the findings. And the judges, they sometimes they'll just read, and it's so painful. Nothing is more painful to sit in a court for 20 minutes and watch a judge read a finding and order, and you're like, oh, please just adopt the findings and orders on page 12. Don't say, I find that the judge is contrary to the child welfare. But they're so scared of losing money that they do it, some of the judges. The good ones won't. It doesn't have to be word for word. You just got to sort of give the intention. During the audits, if you're not sure, you can pull the transcript of the proceedings. If the judge says, I'm adopting the findings and orders, I'm adopting the 4E findings, that's going to be good enough to pass an audit. Also, when it comes out of the judge's mouth, it becomes law. It becomes the ruling. So if a judge says, I find it's contrary to the child's welfare, contrary to the welfare of the child remaining in the home, boom, you're there, you're done. You've met that criteria. This is one of them. This is one of my favorite ones. Oh, this one says if you don't make that finding at the first hearing, you lose eligibility forever. Judges and lawyers know this, especially county counsel and children's lawyers. They know. That's why when you come to court for the first time, sometimes they'll continue the case for a day, but no one will continue the case until these findings are made because it preserves the eligibility. Judges are taught this. CDSS spends $1.1 million every year to pay the Judicial Council to have lawyers remind the judges of how important this is every year. Which is ironic because the state of California has never written a check back to the feds for 4E, but yet we spend $1 million a year to make sure. Do we know if the reviewers look at parentage determined by the court? Yeah, they do actually, because they pull the court file. The 4E reviewers, what they use for their review is the court file and the agency's file. So it'll be on the minute orders. They look at those minute orders very closely. So if the court has made the finding on the minute order, it should be there. If it's not on the minute order, they'll pull the transcript. If it's in the transcript, you're good to go. If it's not on the minute order, it's not on the transcript, you're going to have an audit problem. Um, but for those of you who know, they only pull about 60 cases for an audit. That's for the entire state. And LA takes a good percentage of those cases, at least 10. So for the other 57 counties, we're looking at about 50 cases. So, and it's not one from 50 counties. They'll put two or three from again. So the chances of one of your files ever getting pulled for a CFSR audit are actually pretty small, but we want to make sure we have 100% accuracy in all the files. That's what JIRTA does, the Judicial Review and Technical Assistance Team. That's the group of lawyers for the Judicial Council that come out and double check all the judicial findings and the stuff to make sure, because they want 100% compliance. So when those audits come, they don't have to worry about these things. Here are the other findings. Super important. When I teach lawyers, I tell them that this when you're at a detention hearing, these are the findings that matter most. There's the reasonable efforts finding, because if you want to get a kid home at the detention hearing, you'll talk about whether reasonable efforts were made to prevent or eliminate the need for removal. Bad guy's gone now, it's safe to return. I've gotten plenty of kids home because I've made this argument. And the judge has to seriously, substantively consider whether reasonable efforts have been made at this point, and the good ones do. Um, all right, here are the findings. Um, these are them. This is your life, and hopefully you'll know more of this. And here, this is another slide I want to pause on for you guys, because these are the Judicial Council forms. Most counties now are using these forms. These forms were developed by the JIRTA team to ensure that all the right boxes get checked, so that all the eligibility findings can be made 100% of the time. That's why these forms exist. And counties who use these forms tend to do extremely well in the audits. Adet, if you want to go ahead and jump in, go right ahead. She got to unmute first, though. There you go.
Okay, sorry. I was
It's okay.
trying
And you
to
got to move your
make
camera
it
down
work.
so y'all got to see your face.
So, sorry. So we had an issue pop up with some findings that, okay, so it was an inter-county transfer from a different county, which doesn't happen very often in our county because we're in Plumas County, so we're a really small
Hmm.
rural county. But the order that we had received did not have the word vested in it. So we had to go round and round, because when we had our audit, the auditor let us know that if it doesn't say exactly what is on the JV 410, that the actual child is vested with the county, that we are not allowed to accept it. But on the other form, it was like so close, it just didn't have that word. So then we were kind of left like in this conundrum, because ICTs we're supposed to pick up as is. So we ended
Right.
up picking it up, but we left a big like journal note in the case, like, hey, this is probably going to be a finding, because we were already told by the auditors that it had to have the specific verbiage in the court order.
So that is exactly what you all should have been told, and not exactly true. Um, so, but that is exactly what you want to strive for. You can contest that particular finding, that particular case. You can make an argument to the feds, but that's going to be done at a level beyond all of our pay grades. That's going to be done at the CDSS office if that becomes an issue. And that fight is going to be. So what you were told and what you just told everybody is exactly right. And that will get you 100% of the time, which is what you guys are striving for. You guys are striving for 100% accuracy 100% of the time, so that the dollars always flow. So that's really good advice. And if I'm the lawyer looking at that, I'm fighting that. Like, come on, people, form over substance. Let's not do that. I want to talk I don't know if Nicole, if you're the same person that mentioned de novo in the comments, but I'm so glad you brought it back up, because I didn't want this webinar to go without me mentioning what a de novo hearing. De novo is Latin for the first time as new. All first time hearings are essentially de novo hearings. Um, I, in terms of, if is there a de novo detention or all the hearings are essentially de novo hearings, unless you have to go back and do something again. So when you're doing a hearing for the first time, that is a de novo hearing. It's not been done before. If you have to have a second or a third or a rehearing on an issue, then depending on the kind of hearing and the law that applies, that may or may not be a de novo hearing. A lot of times the Court of Appeal will reverse and say, I order you to have a de novo hearing, and basically do it again like you didn't do it before because you did something wrong the first time. So erase it and go back and do it again. You see it with ICWA a lot. Um, And so, but I don't want you to get caught up in the word de novo. That is not a juvenile court thing. Just think of it as the hearing before you, and if it doesn't get overturned on appeal, if everything stays, that is the hearing that you're working from, and these are the findings and orders that you are dealing with. I'm so glad you brought that back up. This is the same form for initial appearing. Again, if your county's using these forms, you should get it right 100% of the time, save for, accidental human error, which again, you could fight. If you're not using these forms, so um, then it should reflect these in substance. And again, the auditors are looking for substance, not form. If you're hitting the major points, um, a de novo, is it similar to ex parte? I love this question. Thank you. No, a de novo hearing is an order from another judge to do it again. An ex parte hearing is I'm coming to court. I'm asking the judge to do something without letting everyone else know, or I'm making a request ex parte. Judges will never engage in ex parte conversations. That's like if I walk into a courtroom and I say, Judge, I want to talk about the Smith case with you. And he's like, Yeah, what are we going to do with that, you and me? If the other lawyers aren't there, that's an ex parte communication. That's not okay. No judge is going to do that. An ex parte hearing, you see it in family court all the time, which is, hey, something emergent is happening. I need to get in front of you right away. I'm making this request for an ex parte hearing. Can I please have a calendar? Oh, I love it. It's Latin Day. And so, does de novo apply to 387? No. 387 petitions are supplemental petitions. Those are also kind of de novo hearings because what a 387 is we're going along in our case, but the prior dispositional order has been ineffective, which means that what we were going to do is no longer working. And because there are some rights involved, we have to file a supplemental petition to undo what has been going on. It's a parallel proceeding. So your underlying eligibility remains. 387s do not impact underlying eligibility, but it's like a second level, your case is this going forward, and then a 387, 342, or even a 388 is like a second line. Because, oh, it reminds me of a joke. What's this? I don't know, but here comes another one. So, I learned that when I was like 4. So, but that's like you got the one line, and then a 387 is another line that's coming, and they run parallel until the 387 is resolved, and then you're back on that original line again. So, for eligibility purposes, stick to the original. Don't worry so much about Don't worry about the supplemental petitions. Nunc pro tunc means backdated, essentially. And that you can't, the reason you're asking, I get it, because in eligibility, you can't go nunc pro tunc if you mess up on the original findings that we just talked about. If you don't make those detention findings on day one, you can't go back and undo that mistake and make it okay. For anything else, you can. And so where you see this typically is with relatives. Relatives take the kid, but it takes 3 months for the eligibility to come through. Well, guess who's going to get a backdated check for those first 3 months? That's the concept of nunc pro tunc, is going back in time as if it happened on that original day. Um, you can't go nunc pro tunc with eligibility, especially in that initial hearing. You can try to go nunc pro tunc on subsequent proceedings, but as Idette was talking about, that's going to be really hard to do. So nunc pro tunc ineligibility is sort of a bad thing. 387 supplemental petition, sort of a nothing thing. De novo ex parte, also sort of a nothing thing for eligibility workers from the juvenile court's perspective. But there are cases where this could matter a lot, which is why these are amazingly good questions. So thank you, smart people. How am I doing here? Okay, 26 minutes to get through 3 more sections. All right, we can do it. And keep asking your questions because I love it. Remember, if you're thinking it, others are. Um, After that initial detention hearing, you come back and the court has to ask itself, are the allegations in the petition true or not? Yes or no? Did the parents abuse or neglect the child? Did the child commit the offense he or she is being accused of committing? Yes or no? That's what a jurisdictional hearing is. For those of you who watch the Law and Order, bump bump, any of them, are they guilty? Yes or no? That's the adjudication hearing. A lot of states call this the adjudication hearing for that reason. But jurisdictional hearing is, are the allegations true or not by a preponderance of the evidence? And if they are, then the court's going to do the next thing. And so let's see. Oh yeah. Same thing. If they're true, we're gonna do the next thing. So yeah, love this. The petition which was filed, a month ago or 60 days ago or 70, 90 days ago or a million years ago if you're in LA. These are the considerations. So jurisdiction hearing just simply means, are the allegations true or not? It's that simple. It's very criminal oriented. So it's when I teach lawyers, I'm like, this is the one moment in a dependency case where you're like a criminal defense attorney, or you're like a prosecutor. Are the allegations true or not? You only have to prove it true by a preponderance of the evidence. I want to get into the, prima facie evidence, preponderance, reasonable doubt. I don't think this is the class to get into that, but maybe I could drop it in the chat before we finish. Because that stuff is really important to the lawyers in the juvenile court, not so much for you. Either it's true or it's not. If it is true, um, then the court will conduct or set a dispositional hearing. That's where we're going next. Pause for these. Um, we are still allowed to use court transcript if any of the three findings were inadvertently left. Yes, yes, you can still use transcripts if it's in the transcript that it happened. So that's good. But if it didn't happen, you can't go back and pretend like it did at this initial. That's the issue. Good question. Um, so this is the form. This is the 412. These are the findings and orders. This is going to be an important form for you to know. Um, thank you, Geraldine. Awesome. Um, and then I think we get to disposition. This is the easiest one to teach. Why is it sometimes that they're separated? Yes, excellent question. I'll ask that. I'll answer that in a minute. Disposition means in English, so what? The allegations have been true. The court has taken jurisdiction, which means the judge is going to make decisions about this child because of what has been found to be true. And then what you have to remember, one of the three things I learned in law school was if the question starts with, can the judge? The answer is yes. If the question starts with, can the judge? The answer is yes. When you're talking about a dispositional hearing, the question is, can the judge do that? The answer is yes. The judge can do whatever he or she wants. You can dismiss and return custody. You can give custody to the other parent. You can lock the kid up for a really long time. You can keep the kid out of home and order reunification services. You can do a whole lot of anything at this point at disposition. And so one of the reasons why sometimes juris and dispo are separated, and I use those terms, I use the slang, is for that very reason, which is like we know these things are true, but we're not exactly sure what we're going to do with it. My humble person, all juris dispo hearings are bifurcated. Nevada County, all hearings are bifurcated. We only deal with jurisdiction and we won't deal with disposition until we figure out if the allegations are true or not. Because why would we want to try to figure out what's going on with a kid until we figure out if the court's going to take jurisdiction or not? Logical. I hate it. I would much rather do these things combined, much like a criminal case where you plea bargain and you come to an agreed upon sentences. Sure, I'll take the misdemeanor and do no time and pay the fine, but I'll agree to do the anger management classes, right? Um, Juris and dispo are really tied together. Like, I will tell most of my clients, like, I don't care what you find to be true as long as you give me my child back, right? I'll admit to anything as long as my kid can come home. And of course, when you have them together, you can make that kind of a deal. We'll agree to sustain these allegations and you'll agree to send the kid home. Beautiful. It's lovely. We have a deal. Now, if you have khaki involved, that's a completely different issue. If you have, sexual molest involved where you're going to have to do all kinds of things as a sex offender, that could be a problem. But most cases where we're dealing with drugs, like, yeah, I'll admit to using drugs. Give me my kid back because I'm clean now. It's been 60 to 90 days. Give me my kid back. You can negotiate those things together. And that's dispo in a nutshell. So, again, these slides are so good, and I wish we had time to just pour over every single one of them. But this is what I just said to you. Trust me. Same with delinquency. Let me pause back there for a second. Yeah, you can see that's the number four. You can send the kid back to the parents. You can send the kid to a relative. You can do anything. If you send the kid to an out-of-home placement, that is a 4E eligible placement. If you do that at disposition, which is where I think we're getting to, I want to make sure. Um, yeah, we are there, which is why I want to make sure I highlight this slide before we go on. Because in almost all juvenile court cases, both delinquency and dependency, the disposition orders, yes, they're coming. Um, the disposition orders are really critical. This is an actual removal. So kids are not removed when they're taken from the home. They're only temporarily detained. But when we get to dispo, if they don't go home at dispo, then they are removed. And when they're removed, the eligibility will continue beyond this. And so that's a really important point. The difference between detention, where everything is temporary, and dispo, where the child becomes a dependent of the court or the child becomes a ward of the court for eligibility purposes. Those are key findings. So this is a really important hearing if there's going to be ongoing eligibility. And so that's why these findings are really important. Because what happens at dispo, I used to think that disposition was by far the most important hearing in a juvenile court case. Being someone who now represents clients, I realize that the detention hearing is by far the most important because that's the first impression hearing. If you can get them at minute one and you can turn the lights on in their head, you're going to be fine from the family's perspective. But from an eligibility petition, this one is really important. So when disposition hearings are conducted, it's because we figured out things are true, and now we're trying to figure out what to do as a result of the things being true. Um, so excellent question. Yes, we are. No, I don't think you're determining. That's a really good question. I actually don't know the answer to that off the top of my head. Can somebody jump in and answer Irma's question? That is an eligibility question, a very specific eligibility question. Um, if you know it, please let her know. In my 29 minutes, I sort of don't want to go there because I got to get through a whole bunch of other things. But you were asking an eligibility specific question, and yeah, Miriam, can you handle that? That would be really great. That is the right answer, of course. Um, so keep going because I want to get to status review hearings. And thank you guys. Yeah, my teachers who identified yourself in the early one, this is your opportunity to shine. Answer Irma's question for the group, please. Um, I'm going to talk about status review hearings. Many, many times in a juvenile court case, whether it's delinquency or dependency, I'd say 80 to 90% of the time, the judge takes jurisdiction. Um, and I'm going to let that chat keep running. So keep going, Miriam. Um, so the judge takes jurisdiction, the judge proceeds to disposition, and about 80 to 90% of the time, the judge sets another hearing. If the kids go home, they'll set a status review hearing pursuant to Welfare and Institutions Code Section 364. If the judge keeps the kid in foster care, they'll set a 366.21 subdivision E. These are in your flow chart. But these status review hearings can last for as little as 6 months, sometimes sooner if parents really fall off the face of the earth or they wind up in state prison. Um, that can be less than 6 months, which is just a lovely little soapbox that I'm not going to get on because I think that's ridiculous. California is only, yep, I'm on it. Soapbox time. California is only one of 8 states in the country that terminates reunification period in less than a year. Um, and it's ridiculous and I hate it. It's one of my bucket list goals is to get that changed. The federal law that applies, Adoption Safe Families Act, says you have 24 months basically to try to reunify. And most states give their parents 22 to 24 months to reunify. States are allowed to shorten that period, and 8 of them have chosen to do so. Alabama shortens it to 3 months. California, for kids under 3, looks at it at 6 months. So, if you're a big fan of Alabama or a big fan of California, that we have that in common. Um, so status review hearings, though, can last, and I don't know how much I want to get into this because I want to leave a few minutes for questions. Um, but they can last from you have to check in every 6 months. That's statutorily mandated. Um, and the reason it's statutorily mandated is for eligibility, is to make sure that all the fine because federal law requires that the eligibility be good for a year. But California said, well, we're going to come back in 6 months to make sure that everything's good. Which is why one of the main reasons why California never writes a check back to the feds is because we're looking every 6 months. So we have 2 shots to get it right within that calendar year to keep the eligibility flowing. And we pretty much always do. It's a very rare case where you're going to find like a no reasonable efforts finding for 2 straight times. Almost never happens these days. So we're looking 6, 12, 18, 24 months. And there are very specific statutory criteria of how you get to and what happens when you hit a 6 month review, when you hit a 12-month review, when you hit an 18-month review, when you hit a 24-month review. There are some very specific things that happen that have to happen in order for you to either come back home if you're a child, or continue the reunification process. I spend 2 hours on this for social workers. I spend 2 days on this for lawyers. So, what you need to understand is that these status review hearings have very particular nuanced set of rules in terms of when they must be set, and the findings that must be made if you want to achieve a particular result. And those findings, this is the thing that I love to say, those findings must be supported by the evidence. So if you're going to find reasonable efforts have been made or active efforts have been made, there better darn well be evidence that active efforts have been made. If you're going to find that there's still a substantial risk of detriment to returning the child, you need to find evidence that there's a substantial risk of detriment. That doesn't always happen because sometimes we just really like the family, we want to give them more time, or we have a really lazy social worker who doesn't want to do their job, or we have a really mean minors attorney that just doesn't like this family. Um, Here are the findings that must make for the eligibility to keep flowing. Again, the court is very aware of these findings. The court is pressed all the time by county council and good minors counsel to make these findings all the time, and they must be made. And if you're using the judicial council forms on your minute orders, they will be made because the form itself forces you to look and check the boxes. Likely date, transitional living, successful care. A, a quick footnote about number 5 here on this. We gloss over this a lot. And in fact, the likely date is almost always the next 6-month hearing. Um, the JURTA folks really try to teach judges to stop on these findings and make meaningful findings. Doesn't always happen. There's too busy. There's 20 cases on in a day, families coming in and out. These are not the priority. They'll make the findings, but they're not going to stop and go, is the likely date really 6 months from today? They're not going to do that. Did that 14-year-older get set flight should be said. There's a T missing, by the way, Geraldine, in that one, in number 5. Because I was going to go into French for a second, then I remembered I don't speak French. So, the services c'est fort in the Cape Span. That's all I can do. And croissant, which I also mispronounced. So, um, yeah, are they really set forth in the TILP? That's one of I love TILPs. I love the concept of TILPs. I hate how they're implied. Thank you, Ariel. That's exactly what I needed right now. That's the perfect punctuation, what I'm trying to say here. Here are the Judicial Council forms, which are so very good, and the content in these slides is so very good. Um, so yes, excellent. So if reunification is successful, the flow chart leads you back up to the 364 hearing that I mentioned earlier. So if you're looking at the flow chart and you're in the status review line and you successfully reunify, whether you're a delinquent and you get to go home or whether you're dependent and you get to go home, you go back up on the flow chart. If you're in a dependency case and reunification is not successful because no parent or child is able to reunify, no parent or guardian is able to reunify, then you go down, much like the joke I told you earlier. If you're a parent and you don't reunify, California, unlike most states, California ties parental rights to the success of the reunification period. So if you are successful, mazel tov. But if you are not, you're going to lose your parental rights unless. Most states don't do that. Most states are like, well, if you're not successful, we still have to file another petition to terminate your parental rights. We still have to prove all kinds of things to terminate your parental rights. California, again, super conservative, not as blue as you might think it would be. California says if you lose reunification services, we're going to adopt your kid out unless you can stop us. And what I tell my parent clients is that adoption train leaves the station, and the only thing you have to stop it is a crowbar. So you better deal with it. That hearing where you lose your parental rights is called the selection and implementation hearing, or the 2-6 hearing, in most counties. 2-6 hearings are bad. No judge likes a 2-6 hearing. Why are the slides not advancing? I just tried to advance the slide. Can I go back? No, can't go forward. Geraldine, can you help me? The slide should be advancing. Oh, there we go. Hi, faces. Nice to see you all. I'm going to keep talking about 2-6 hearings while we advance. 2-6 hearings are bad. One of the things that every dependency judge will tell you is the thing they like least about sitting in the dependency assignment is they hate terminating parental rights because it's a failure. If we tried to give you the chance to reunify and you didn't reunify, then we as a system has failed the family. Obviously, there's an exception to that, which would be like if we didn't give you the chance at all, there's something called bypass, which happens at disposition, which is if you did something so yucky, like horrible physical or sexual abuse, we're not going to try to reunify you. If you did something, if we've been there, done that many times, like this is your sixth kid and you've lost parental rights to the first five and you're still using, we're not going to try. So judges feel a little less bad about terminating parental rights if you're bypassed. But if you were given the opportunity to reunify and you had status review hearings, then we're going to be sad at the 2-6. And we're still going to be sad at the 2-6, even if we bypassed you, because it's no fun to tell a child when they're older that your parent didn't reunify with you. And so we cut off their parental rights and we adopted you out to some strangers or a relative. Like nobody really wants to say that in a courtroom. Sometimes that is the best possible thing that can happen to a child. Sometimes not so much. Andrew Bridge has a new book out. Andrew is a former foster kid um, who writes about this stuff. He went to Harvard Law School. I love his view on this. Like sometimes it's great. It's a blessing that kids can be adopted by these people who love them and step up. And sometimes we're just creating the next generation of trauma and problems. Um, that's essentially what a 2-6 hearing is. Findings that terminate parental rights need to be made. I'm going to go right to that slide when it comes back in. Um, the last thing that happens on these flowcharts for both delinquency and dependency, I guess I should talk about non-minor dependence. So the last thing that happens for families is if rights are not terminated. There's another option for guardianship, which is essentially the same as terminating parental rights, except it can be undone by a parent. But in terms of eligibility, the case is closed. There are kin gap requirements. That's a specific thing that you might have to deal with in terms of placement before guardianship benefits can flow. Um, if you have questions about that, by all means, drop them in the chat. But if we can't do adoption or guardianship, we're going to put you in planned permanent living arrangement, which is nothing planned, nothing permanent, and horrible living arrangement. It means it means all options are still open until you turn 18. Um, but none of them are good so far, which is why you're still sitting there in PPLA. So we really don't like um, planned permanent living arrangements. Oh, there we go. Hey, back up. So I'm gonna land it on this slide that yeah, I really want you guys to. These are the things that you absolutely have to know about selection implementation hearings. Um, and so it's here in your materials with hyperlinks. Yay, great job, Geraldine. So when you get this stuff, um, it's all good. Oh, there you go. Um, and so this is what I was talking about. It means all options open. We still look every 6 months. There are certain findings that have to be made, just like all the other hearings. But trust me, if you're in planned permanent living arrangement or post permanency, unless you're in an adoptive home, sometimes it takes about 6 months for the adoption to finalize and for things to come through. And so you have these hearings that continue. But if the kid's just waiting for adoption, that's fine. But if the kid is like a teenager or like a fire starter or killing the cats, and you're waiting for this kid to grow up and become a criminal in the adult system, that's bad. So when I teach kids attorneys, I'm like, if you have a kid in PPLA, you have to work a lot harder because your kid is not doing well. You have to work harder. If you're a social worker and you've got a kid living in an STRTP or in a foster home, bouncing from home to home, it's bad. Sometimes we do PPLA because the caregivers don't want to take guardianship because the kid is difficult and they really like the support of having a social worker come every month. That could be okay. That could work. Right tool for the right job. But as a general rule, these are not good things. And these are the findings, of course, that you must make. Um, so a word about non-minor dependence. Non-minor dependents are foster kids who are now foster youth who are young adults from 18 to 21 years old. And AB 12 was the initial bill that made them non-minor dependents. And AB 12 is a benefits bill. So when I teach AB 12 and I teach about non-minor dependence, what I say is whatever you were eligible for, and I do mean eligible, I picked that word specifically for all of you. Whatever you were eligible for at 17 continues now until you're 21. Your eligibility for everything continues until 21. Now, because you become an adult, at 18, it's nuanced, like education rights. Um, you get your own education rights at 18. Medical decisions. Now you're 18, you can make your own medical decisions unless you're conserved. But most kids who turn 18 can make their own medical decisions now. So the benefits, the shape and the form of the benefits changes, but not the entitlement. The entitlement now continues until you're 21. That's what being a non-minor dependent means. There are some strings to being a non-minor dependent. This is one of them. You have to be in foster care. Here's the review process. Um, here's the purpose, which I talked about, benefits, basically. Here's the flow chart, which again takes an hour to teach that we don't have. Here are the hearings, yes. And we've made it very easy for youth 18 to 21 to become non-minor dependents. They can come in, they can come out, they can opt in, they can opt out, they can do whatever they want. It's there for them until they're 21. And of course, if you're talking about housing, for those of you who work in the THP area and housing, that housing can continue to 24, 26. Same with Medicare, Medi-Cal, they can go up to 24 or 26, depending on your case. And that's how non-minor criteria. So there's one thing, this is really good stuff. I'm looking for the eligibility requirements to remain a non-minor dependent. I don't see them, but they're in there. I thought I had a question. Did somebody answer it? Looks like you did. I'm hoping that we could take the next 4 minutes. Here are the summary. The timing of hearings can impact court orders drive eligibility. Absolutely true. Types of hearings impact the case. Essential. Yeah, this is all open book. This is all open book. Don't be afraid to ask if you're not sure. Ask the question. I'd rather you ask the question and than not, because your jobs are so essential. And if you don't get it right, it's not going to be right. Um, when I teach lawyers, actually, ironically, dependency lawyers, one of the things I teach them is whatever you do can be undone. Not so with eligibility. Whatever you do needs to be as right as possible so that families and these children can have access to this money that could be life-saving, and life-challenging. So, um, I'm going to look back at the chat. If you want to unmute, please do. Geraldine, I'm about to turn this back to you.
Awesome. Thanks, David.